at some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob because I mean we've got robbery, aggravated robbery, another robbery. It's anyway. So good morning. Are you Veronica Randall?
It's Gianna.
And Ms. Randall was previously in court in clause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yes, Sean.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? No, no additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yes, Sean.
All right, Mr. Vasquez, you may proceed with argument.
Gianna, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition and that the court thinks best would help her to quit offending. And in lieu of that, I mean, in the alternative, you're not asked for something less than the 6 years if she's going to.
Anything else, Ms. Malfini?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob because I mean we've got robbery, aggravated robbery, another robbery. It's anyway. So at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25 DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 25 DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Will run concurrently.
So instead of stacking into 12 years, the total time stays at 6.
I will sign
Still
a
significant, but
dismissal
legally,
in
that's a
clause
big
number 25
differentiating.
DCCR 1686 as part of this agreement. I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments, you're ineligible
question.
under Texas law
Do you
to
think the
possess a
system gave
firearm
enough
or ammunition.
chances,
Possession of a firearm
or is this
or
exactly
ammunition
how
could lead to
repeat
charges
offenses
against
should be
you.
handled?
Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Right, ma'am, you can go back with the bailiff.
Thank you.
All right, sir, you're Thaddeus McCray.
Yes, ma'am.
And so, Mr. McCray, in clause number 21-38959, has a motion to revoke his probation, the underlying offense of aggravated assault causing serious bodily injury. And then we have clause number 26 BCCR 0399, which is the new indictment charging Mr. McCray with the offense of murder. Ms. Brazo has filed a motion asking that I reduce the bond in the murder case. And while we're here, we obviously need to talk about a bond being set in the MTRP case as well. And so the bond in the murder new indictment is set at $1.5 million. And then there's no bond in that MTRP. Is that correct?
That's correct.
All right. Are you, Mr. McCray, best you can raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Brazo, you may proceed.
Would you state your name for the record?
Right.
And we're here today on the motion to reduce your bond that's currently set at $1.5 million to $50,000. Is that correct?
Yes, ma'am.
If the court were to reduce your bond, do you have any assets that you could sell to make money to possibly make your bond? Do you have any means of making that bond that were reduced to $50,000?
Possibly.
Okay, could you explain?
Like just a car, like I was just renting things like that. So personally, I don't like own a house or anything like that. I do it on my.
Speak up. I'm sorry.
Oh,
I
excuse
have
me.
to hear you, and so does the court
I
reporter.
don't own a house or anything. I was renting, but I do own my car.
Do you have?
So that'd be my own means,
Okay.
and then my other assets like clothes and stuff like that. So
What about family members? Do you have any family members that could potentially help you
that's
post your bond?
that's a good possibility.
And are you asking the court if you are placed, if the court does reduce your bond, that you be placed on house arrest or have a GPS tracking device that would only allow you to leave your house for meetings with me, your attorney, or medical purposes?
Yes, ma'am.
Where would you be residing? That relates to my bond. If that were to happen, where would you reside?
More likely, I have to check with my sister.
Is that the only place that you would have to go?
No, now, but I know, friend, I know he's real busy. They both stay in Houston. So technically right now, I can check with some other family members, but I know they all work and everything, and I have to talk to them first. I just can't say yes and barge into their on welcome.
Now, these family members, are they within Jefferson County?
Yes.
And who are the family members?
sisters.
So you have a sister that is here locally?
Yes, and I have one in Dallas.
Okay, what is your sister's name?
Which-
That's here locally.
Oh, there's a couple of them, but, Michelle,
Shh. I'm having a really hard time
Michelle?
hearing.
yes, that's one of them.
Thank you.
And what is, do you know her last name?
His name is mine.
Okay, I was just, I'm sure. Where does she, do you happen to know her address?
I just know she's staying in the West End.
Have you been in contact with her recently?
I talked to him when I got here, my father passed. Haven't really spent too much time on the phone unless it was like with my good friend. You know, I ain't really had much money to put on the phone. So, I was still in this MTRP phase, so it was really nothing for me to keep in contact with.
Okay, that's all I have, Your Honor.
Any questions of the witness, Mr. Smith?
No, Judge.
Any other witnesses with regard to the bonds?
No, Your Honor.
I am, for the record, taking a look at the probable cause affidavit and the new case. So give me just a second to go through that. Mr. Smith, what is the state's position with regard to bond in each of the cases?
I believe that the bond in the murder case is not set too high, and I believe that he is entitled to a bond in the MTRP because it's a deferred probation, but we would ask that a high bond be set in that. I believe we will be seeking to stack these cases, punishment in those cases. So we believe that he will be in prison for a significant period of time. After he committed the murder, he did flee the jurisdiction and was located in Houston.
Do you know how long that was from the time?
It was, I don't remember, it was several days or more.
Give me just a second. I'm looking back now at the previous pre-sentence report. So just to get an idea of what the underlying, hang on just a second. I'm gonna.
If you recall, Judge, this is the case, we were in trial on the sexual assault and the state had rested. And when the state rested, the defense wanted to recall the victim,
Yes.
and the victim we were unable to locate to bring back.
Okay.
And so that was the reason that he pled to the aggravated assault rather than was sentenced by the jury to the sexual assault.
Gotcha.
Your Honor, if I could allow Mr. McCray to respond to the fact that, or to the statement that he was in Houston. If I may.
Sure.
Okay.
I was never in Houston. I never left this jurisdiction. I was found at my ex's house the next day. I never left.
And on Euclid.
Yes, I never left.
Okay.
So for me to flee, never left.
And that is correct, Your Honor. He was arrested at Euclid, and there was some steps that were taken after that to search the residence,
Right.
so forth. But it's my understanding from that point, which was either the next day or within a few days, he was apprehended there.
Okay. I think you have some misinformation on that maybe, or.
There was some info, I don't have the file with me, Judge, on that. I just remember reading that they had suspected that he had been in Houston.
Okay.
But now that I think about it, we have found the motorcycle that was used in the murder.
There's no more.
You're thinking of,
different.
You're thinking of a different case.
It was that one.
That's the other case I've got cited. I apologize.
Yeah.
I'm getting confused.
Okay.
Do you have your file in this case?
I don't have it down here. It's upstairs.
Okay, so. On the offense date, okay.
Your Honor, also, if I may allow Mr. McCray, to speak about this, since the underlying offense for him being placed on deferred adjudication, there were some allegations made as to what happened, that he would like the court to be aware of, and I wasn't part of that.
That's all
case,
done,
so I
on
just-
probation
okay.
for it, entered a plea of guilty to the aggravated assault. I was there, listened to
Okay.
the trial. I don't need any other information on that. So in cause number 21-3855-959, I'm sorry. Which is the motion to revoke unadjudicated probation. I'm going to set the bond in that case at $400,000. Condition of that bond, if made, is that Mr. McCray would be on house arrest with a GPS monitoring device. I'd obviously have to have an address locally where he would be. And then in cause number 26, DCCR 0399, I'm going to sorry. I'm going to grant the motion to reduce the bond. I'm going to reduce the bond in 26 DCCR 0399 to $1 million. Condition of that bond also, if made. A condition of that bond, if made also, is that you will be required to be on house arrest, wear a GPS monitoring device. We'll get the case set for an announcement, obviously, make sure, I'm sure there's a lot of discovery. Has all of that already been turned over? Is there anything missing?
I believe that we have received everything. I'm in the process of reviewing it. It's quite voluminous. So,
All right.
If something comes up, I'll let the court know.
All right, Mr. McCray, I'm sure Ms. Prazo will be out there to start going over the discovery with you so that we can see about getting an announcement which way your case will go at the next court date. All right, you can go back with the bailiff.
Thank you.
Thank you.